Hello, my name is Samantha Bertani, and for this advanced forensic psychology course, I will be sharing a PowerPoint presentation on guardianship. To start, in order to understand guardianship fully, we have to first address civil competencies. These are civil matters that raise concern for one's functional incapacities, which make them unable to perform tasks or make decisions. Much like other competencies, the presence of mental disorders or intellectual disabilities does not guarantee incompetence, because one can exist without the other. Two circumstances exist where competence is of concern. These circumstances are the only instances where it is justified to take away an individual's principle of self-determination. This principle basically states that people have the right to decide what they want to do. So the circumstances that can prevent this are, number one, when significant harm to others can result from their actions, or number two, when they are incompetent to make the specific decisions in question. When competence is concerned, it can be difficult to assess, partly because competence depends on context in legal settings. This means that depending on the decision to be made, competence levels needed vary. For example, harder, more extreme decisions require higher levels of competence from individuals. Now that we have covered the first portion of civil competency, we can now get into guardianship as its own form of legal competence regulation. Guardianship is defined as a legal mechanism by which the state delegates authority over an individual's person or estate to another party. This concept has been around for some time, and it got its origins from Roman and English common law, where the sovereign had to protect the estates of those who were unable to do so themselves or deemed incompetent. This is also where the start of parens patriae originated. I apologize if there's a mispronunciation. This is where the state regulates the decisions made by children, mentally disabled, and civilly committed individuals. As time has progressed, so have these standards for regulating competence. When guardianship is concerned, it started off very easy to obtain guardianship in courts. As a result, in the 1980s, reform took place that started a goal of making the process more rigorous. For guardianship, these reforms were a requirement of using the least restrictive alternative, some of which will be covered later in the slideshow. Additionally, reforms stated that there should be restrictive use of emergency guardianship, and once known, a full hearing should take place as soon as possible. And finally, the presence of proposed ward should be advised at the hearing. These were all made with hopes of protecting the individual. Next, we will address the types of guardianship. First, there is general or plenary guardianship, which means a guardian will have total control over the ward, person, estate, or both. Next is specific or limited guardianship, where restrictions of power are placed for specific types of decisions. Although limited guardianship would seem to be the less restrictive choice for guardianship, it is often not used for many reasons. These include vagueness, biases of judges who may presume total incompetence, lack of resources, or failure to provide specific information regarding limitations by respondents or experts. Next, we will address one of the first steps regarding guardianship in proceedings. This is determining a need for guardianship. Concerning de jure incompetence, little requirements are needed to determine whether this is legal. This includes how old one is and if they're civilly committed. Proceedings only occur when de facto incompetence is concerned. When an allegation is made, the person making the accusation is able to petition to declare incompetence subject to guardianship. There are some major issues and risks associated with the ease of these processes. These concerns include varying requirements for monitoring guardianship, failures to track active guardianship, misuse of Social Security funds by guardians, failure to file reports and inventory of assets, and most obvious an issue is that once a guardian is appointed, it becomes the incompetent individual's responsibility to initiate a restoration proceeding if wanted or needed. These are only some of the barriers for the ward in guardianships. These can be illustrated by the fact that only 25% of hearings for competency and guardianship lasted less than 5 minutes, and 58% lasted less than 15 minutes. This does not seem like an adequate amount of time to warrant a decision on competence. Additionally, we see issues arise with the ambiguity of standards of competence to be considered for guardianship in legal proceedings. It was once the case that only a threshold of intellectual disability, mental illness, senility, or incapacity to properly care for oneself or estate was needed. The issue here can be seen by how different interpretations can lead to different results. More modern statutes try to fix this by focusing on the ward's thought processes. This shift in focus was shown in the Uniform Probate Code, which defines incapacitated individuals as any person who is impaired by reason of mental illness or disability, advanced age, chronic use of drugs, chronic intoxication, or other causes except minority, to the extent that he lacks sufficient understanding or capacity to make or communicate responsible decisions concerning his person. As one can see, this definition still leaves room to be open to interpretation, and as a result, it was rejected by the Utah State Court in Boyer. It was replaced with standards that it does not apply unless the person is also unable to care for his personal safety or unable to attend to and provide such necessities as food, shelter, clothing, and medical care where without physical injury or illness may occur. As you can see, this returns standards to one where inability to care for oneself is the basis for competence. Here we are discussing how this determination is assessed. One way to do this is through clinical evaluations, the goal of which should be to assess functioning of the individual. It is also important to consider that those evaluations are not required or mandated, but needed to be conducted if requested by the petitioner or subject. When conducting evaluations, it is essential to consider a few things. First, a clinician should focus on the psychological consequences of loss of decisional autonomy. Additionally, they should conduct assessments on a range of functions the individual can perform and not focus on the diagnosis or symptoms. Specific evidence about functional deficits is needed to help inform proceedings. Clinicians also need to pay attention to whether the functions in question can be helped by assistance from other resources. These are part of the less restrictive alternatives to be addressed later in this PowerPoint presentation. Finally, clinicians should be sure to keep updated on the newest strategies or research on performing competence evaluations. When performing competence evaluations, it is essential to consider the measurement instruments used. There are over 70 published instruments that clinicians can use in competence evaluations. When using these instruments, it is also important to consider when functional deficits are measured in error. This includes when deficits can be attributed to measurement error due to extraneous factors like hearing, vision, or reluctance. And secondly, is environmental conditions that impact perceived capacities of the individual. An example of this would be when they live in an environment that does not promote making decisions financially, they might feel a perceived incompetence. Clinicians should be sure to watch out for these when conducting evaluations. When using instruments to evaluate competence, IADLS are often assessed. These are defined as independent activities of daily living. Additionally, some well-known and used instruments include the DAFS and ACED. First, we'll look at the direct assessment of functional status. This is an 85-item instrument. It addresses several domains of performing activities with an evaluator who awards points for each of those activities. This was later revised to the DAFSR, which is a 55-item revision that removed some items with no variation and added subscales to address medication management skills. Next, we can look at the assessment of capacity for everyday decision making, or the ACED. This is a semi-structured interview where evaluators assess capacity to make decisions with regards to solving one's own functional problems. It looks at 4 elements, including articulating choice, understanding, appreciation, and reasoning. This specific study has good inter-rater reliability and internal consistency. This is part of why it is so important to use up-to-date and studied measures to ensure consensus among evaluators and in the field. It is important to also consider the issues associated with these instruments. This includes there being so many, being an expert is difficult because one cannot be up to date in all the instruments. Additionally, few have been discussed in publications. There is also no general acceptance for most of these as tools for assessing guardianship or competence. Finally, there is a concern that these instruments do not address the particular skills and functions that are needed when individuals are managing their personal or financial matters. Next, we can look at the second issue concerning guardianship proceedings. This is determining who the guardian shall be. This position can range widely. Anyone from family members to government agencies, clinicians, social workers, lawyers, and more can be determined guardians. There are pros and cons to all who take this position, including free versus for fee services, impersonal versus personal interests, conflicts of interest, all of which can affect any of these guardians. When looking at clinicians specifically, they usually are not a part of this portion of proceedings unless there's a conflict issue that requires them to find out the best and inform the court of matches that would meet the needs of the individual ward. The last issue concerning guardianship proceedings is determining what the guardian's role is or what they should do. Once the guardian is appointed, 2 models guide this decision-making process. The first model is that the guardian should act according to objective test. This means that their actions must be what will effectively serve the ward's best interest. And the second is the guardian should make subjective substituted judgment. This is where they act or choose as the ward would have acted if competent. If this can't be decided, the help of a mental health professional may be used to provide informed consent. Finally, I will address the most emphasized portion of material covered in this chapter. In this section of the textbook, this is alternatives to guardianship or less restrictive alternatives. These are important to mention because this chapter pushes the benefits of providing or requirements of less restrictive alternatives in order to decrease the unnecessary stripping of individual rights. These alternatives are plentiful but seldom used. They include advance directives, representative payee arrangements, trust and joint tenancies, supported decision-making, living wills, power of attorney, and PAD, to name a few. Instead of using total guardianship, some of these alternatives may be used in order to protect the individual while still obtaining the same results, many of which can be applied while still competent. Specifically, we can look at advance directives. All states have some form of these, and they are instructions from competent individuals that will direct or authorize how decisions will be made in the event that one becomes unable to make them on their own. They have been around since 1976. One that many may know of is a living will, which helps a person indicate their desires for treatment if they become terminally ill or incompetent. Additionally, we have power of attorney, which can be used for non-terminal situations and when property is concerned. There is even the PAD, or a psychiatric advance directive, which allows individuals to direct in advance what they want to happen in terms of mental health treatment in the event that they become incapacitated. These are all important alternatives to consider in competence proceedings regarding guardianship in order to ensure the individual's autonomy is not damaged beyond necessity. Here I have provided my resources for this PowerPoint presentation. Below is the link to a YouTube video that provides even more information in terms of legal proceedings. It's illustrating what can occur in a guardianship hearing specifically in Illinois. And then below is the reference for the textbook for this course, which I used to obtain majority of the information that I've supplied in this PowerPoint presentation. Thank you for watching. Bye-bye.